What is a temporary injunction? Temporary injunction is also referred as an interim injunction. Interim injunction is covered under Civil Procedure Code under Order 39, Rule 1. This is not the interim injunction, the application is not a suit by itself. It is an application. It is an IA in a suit which is already existing, or an IA can be filed along with this suit for a temporary relief. For example, in a case of partition, the plaintiff has reasons to satisfy the court that the defendant in question is likely to damage or likely to alienate or likely to put up a construction or likelihood of damaging the property or a construction which is already there in the scheduled property which is under the dispute, or he is likely to transfer the shares. So in such a situation, the plaintiff can approach the court with an IA for an interim relief through an IA. So when the court is satisfied that the plaintiff has got sufficient reasons, then the IA can be granted by the court, asking the defendant not to alienate or not to make any permanent changes, or as the case may be, it can instruct the defendant to maintain status quo of the scheduled property. And this interim relief through these injunction orders need not necessarily be to a immovable fixed property. It can be even to a movable property. It can be even for an intellectual property. So when this injunction is granted in favor of the plaintiff, the defendant will be asked to maintain the status quo. That is done in order to preserve the right of the plaintiff over the scheduled property, in order to uphold his rights over the scheduled property being damaged or being alienated or being transferred. However, this injunction is not a permanent order of the court. It is a temporary order, and that can be altered, that can be modified in the main order. However, this comes as a relief because it controls the action of the defendants which may be against the plaintiff's interest.